My lord, the select committee contained 3 other names, my lord, who were connected with the university. One was the executive committee member, another, my lord, was the academic council member, third, my lord, is the former registrar. UGC regulations clearly say that, my lord, the search committee should contain unconnected persons connected with the university.
All right.
51
And my
and
lord-
52.
Mm.
Para 51.
Yes.
It would be appropriate to analyze whether the reappointment of the VC has to follow the same process as a fresh appointment by setting up a selection committee under section 8(1) of the Act as indicated by the Chancellor. Section 8(c) stipulates the manner in which a vacancy in the office of the VC which occurs by reason of death, resignation, expiration of the term, removal or otherwise shall be filled up. The provision indicates that such vacancies shall be filled up in accordance with the provisions of subsection 1 of section 8.
Completely misconceived light, as the petitioners have sought to do. And the extension, my lords, is granted by the Vice-Chancellor. The order granting extension is in your lordship's file. After considering, my lords, the report from the government, the credentials of the petitioner and various other factors, a speaking order is passed, my lords, by the Chancellor in exercise of this statutory power. And certainly, my lords, as far as 13(4) is concerned, UGC regulations have absolutely no overlap. On the larger question, my lords, of the applicability of the UGC regulations, my lords, learned senior Mr. Holla has referred to two orders. There is also the judgment in Loknath of a division bench of this honorable court that when it comes to institutions that are not funded, then the UGC applicability itself is doubted.
Where SLP is dismissed by one sentence or one paragraph order. My lord, the Honorable Apex Court has held that it is not a binding precedent and it is not a finding on merits. Even otherwise, we do not find merits in the contentions. Merits ಏನು ಹೈಕೋರ್ಟ್ ಏನು ಕನ್ಸಿಡರ್ ಮಾಡಿದೆ, ಅದರಲ್ಲಿ ಮೆರಿಟ್ ಇಲ್ಲ ಅಂತ. ಹೈಕೋರ್ಟ್ ಮೆರಿಟ್ ನಲ್ಲಿ ಏನು ಹೋಗೇ ಇಲ್ಲ.
ಅಲ್ಲ, ಅದಲ್ಲ 4ನೇ ಪ್ಯಾರಲ್ ಇರುವುದು
ನಾಲ್ಕನೇ
ಹೈಕೋರ್ಟ್ ಮೆರಿಟ್ ಅಲ್ಲ.
ಆಲ್ ದಿಸ್ ನಾನ್ಸೆನ್ಸ್. ಇದರಲ್ಲಿ ಈಗ ನಾನು ಹೇಳಿರೋದು
ಟೀ ಶಾಪ್ ಕರ್ಕೊಂಡು ಹೋಗಿದ್ದು,
ಟೀ ಶಾಪಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅವನ ಮನೆಯಲ್ಲಿ ಹಾಕಿ ನನಗೆ ಪ್ರೆಷರ್ ಹಾಕಿದ್ದೇನೆ. ಐ ಹ್ಯಾಡ್ ಟು ರನ್ ಅವೇ ಫ್ರಮ್ ದೇರ್.
ಕಿಡ್ನಾಪಿಂಗ್ ಹಾಕಿದ್ದೀರಾ?
ವರ್ಚುವಲಿ ಕಿಡ್ನಾಪ್.
ಭರ್ಜರಿ ಕಿಡ್ನಾಪ್.
ವರ್ಚುವಲಿ ಕಿಡ್ನಾಪ್ ಅಂದ್ರೆ
ಕಿಡ್ನಾಪ್.
ಇದ್ರ ಮೇಲೆ ನಾನು ಇದು ಹಾಕಿದ್ದೇನೆ. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳುವುದಕ್ಕೆ ನನಗೆ ಇವತ್ತಿನವರೆಗೆ ನೋಟಿಸ್ ಇಲ್ಲ. ಹೌ ಮೈ ಲರ್ನ್ ಫ್ರೆಂಡ್ ಈಸ್ ಏಬಲ್ ಟು ಗೆಟ್ ದಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಐ ಡು ನಾಟ್ ನೋ. ಆಸ್ ಆನ್ ಟುಡೇ there is no B report filed or accepted by the court. My lord, I have read to your lordship, my lord, the UGC regulations.
Sir, your submissions were threefold.
Please, my lord.
One is that the search committee did not contain a member of the UGC.
Please, my lord.
So the proceedings in the aftermath of the search committee gets vitiated.
Please.
1. 2, the integrity of the candidate that is continued now is questionable because of 1, 2, 3 incidents, whatever you've indicated. 1. Therefore, writ of quo warranto would lie against him on as a person without an integrity is holding the chair or continuing in the chair. That is the submission.
My lord, one other submission is, my lord, the select committee contained 3 other names, my lord, who were connected with the university. One was the executive committee member. Another, my lord, was the academic council member. Third, my lord, is the former registrar. UGC regulations clearly say that, my lord, the search committee should contain unconnected persons connected with the university.
All right.
And my lord, he was involved in facilitating mass copying of a
Correct.
VTU
The
examination.
integrity. Integrity was questionable.
And no
That-
inquiry has been concluded in that regard.
Submission. Yes.
My lord, then qualification. My lord, he secured only a second class multi-attempt pass BE degree. So he cannot be called as a distinguished academician.
Oh.
My lord, I have produced his degree certificate. He took more than 4 years, my lord, to pass the degree. And my lord, for 1 year it appears he was detained. He scored, my lord, only a second class in his BE examination.
ಅದು ಫಸ್ಟ್ 3 years ಅಪ್ಲೈ ಆಗಲ್ವಾ? ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾತ್ರ ಇದೆ.
ಅಲ್ಲ, first 3 years also is under challenge, my lord, extension also. The first 3 years also is challenged. And my lord, then my lord, this extension was done, that writ petition was withdrawn and a fresh writ petition was filed.
Oh, that was also challenged.
That was also challenged. In this, my lord, that prayer also is contained in this.
Yes, what do you want to show? Really?
My lord, your lordship may kindly see. My lord, the notification at,
Page,
1 second, my lord. My lord, page 92.
I am holding WP 28442.
Please, my lord.
Yes,
My lord, page 92, serial number 10.
amended petition.
ಹೌದು ಸ್ವಾಮಿ. ಅದು ಮೇನ್ ರೀಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಇದೆ ಅದೇ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ amended ಅಲ್ಲಿ ಎಲ್ಲಿ ಉಂಟು? 9,
My lord, it is annexure H3,
yes.
H4. My lord, page 92, serial number 10. Professor Kripashankar. My lord, he is the member of, at the relevant point of time, my lord, he was the member of the academic senate of the VTU. Then, my lord, your lordship may turn to the previous annexure, page 88. My lord, executive council member. My lord, serial number 17 at page 89. Dr. M.S. Shivakumar. My lord, he was the former registrar of the very same university. Then, my lord, one more document, my lord, is annexure H5, page 93. Jitendra P. Nayak, my lord, he was the member of executive council, EC, of the VTU.
All right.
All the three, my lord, one was the former registrar, and other two, my lord, were the current academic and executive committee members. UGC regulations clearly state, my lord, that prescribe they should be unconnected with the university.
All right.
And degree certificate, my lord, is at, then there were series of misdemeanors, my lord, as the Vice Chancellor of KSOU, Karnataka State Open University. Those things, my lord, I have produced at page 63, annexure G. My lord, the audit and accounts department of the government of Karnataka, my lord, had called for the account particulars. It was shielded, and my lord, a private account in a private bank, an account in the name of the university was opened. My lord, actually the accounts are required to be operated jointly by the registrar and the finance officer. In the instant case, my lord, a faculty.
That's the allegation against him earlier.
Previous, my lord, before becoming the vice chancellor,
Alright.
as a vice chancellor of another university.
All right.
My
So
lord,
it touches upon the integrity.
Integrity.
All right.
Integrity and morals. My lord, he shielded all the account particulars.
ಆಯ್ತು, integrity and morals.
Morals.
Details ಏನ್ ಬೇಡ.
ಹೌದು. ಇದು, my lord, he, as far as his distinguished academic thing is concerned, my lord, I have produced the degree certificate. It is at annexure B. My lord, page 27. My lord, second class B degree from Bangalore University.
All right.
Page 27, annexure B.
All right. Yes, sir. Page ಯಾವ್ದು sir?
Page 27, Swami, annexure B.
Yes, sir.
And my lord, this is covered by series of judgments, my lord. If your lordship permits, my lord, already the
ಇಲ್ಲ,
judgment.
ಫಸ್ಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮುಗಿಸ್ಬೋಣ ಆಮೇಲೆ.
Then, my lord, he was kept under suspension for, that is order at annexure C, page 28. Shri so and so ರವರು ಪ್ರಾಧ್ಯಾಪಕರು ಮೆಕ್ಯಾನಿಕಲ್ ವಿಭಾಗ ಡೀನ್
kept under suspension.
kept under suspension for allowing mass copying of a
ಆಮೇಲೆ
VTU examination.
All
My lord, no inquiry has been conducted by the VTU. Now, my lord, he has,
ಆಯ್ತು. Next.
this is, my lord, to show that his credentials. Then, my lord, the other one is annexure E, page 33, my lord, that is the UGC regulations, which I have read to your lordship on the last occasion.
Yes.
Page 33, my lord, if your lordship permit, I will read only one paragraph.
ಆಯ್ತು ಓದಿ.
A person possessing the highest level of competence, integrity, morals, and institutional commitment has to be appointed as a vice chancellor. The person to be appointed as a vice chancellor should be a distinguished academician with a minimum 10 years of experience as a professor in a university, 10 years experience in a reputed research or academic administrative organization with the proof of having demonstrated academic leadership. The selection for the post of vice chancellor should be through proper identification by a panel of 3 to 5 persons by a search cum selection committee through a public notification or nomination or a talent search process or a combination thereof. The members of such search cum selection committee shall be persons of eminence in the sphere of higher education and shall not be connected in any manner with the university concerned or its colleges. My lord, two of them, my lord, were current academic and executive committee members. One was a former registrar. My lord, as a quid pro quo, after getting selected, he nominated him, my lord, on the EC
All right.
for 2 terms. Still, my lord, I understand he is continuing as the EC. So, my lord, on this ground, my lord, the appointment is vitiated.
Quid
Then
pro
my-
quo.
my-
Alla, quid pro quo.
Quid pro quo.
EC for VC.
VC, yes, my lord.
All
EC
right.
membership for VC
Right.
position.
EC for VC.
Please, my lord.
All right.
My lord,
Hmm.
my lord, one sect, my lord, I have furnished
What is that?
judgments, my lord.
ಹೇಳಿ.
My lord, ಇನ್ನೊಂದು ಬೇಕಿದ್ರೆ ಇನ್ನೊಮ್ಮೆ ಕೊಡ್ತೇನೆ, ಅದು ಇಲ್ಲ ಅಂತ ಆದ್ರೆ ಅದು.
ಇಲ್ಲೇ ಉಂಟು ಹೇಳಿ. ಯೂನಿವರ್ಸಿಟಿ ಆಫ್ ಡೆಲ್ಲಿ ವರ್ಸಸ್
ಅದಲ್ಲ, ಗಂಬರ್ಧನ್ ಗಡ್ವಿ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಗುಜರಾತ್. First judgment, my lord. The lordship got it, my lord.
Yes, sir. Yes, sir.
My lord, this your lordship gets the relevant portion, my lord, my lord, judgment starts in page 1. My lord, may I just read the head note, my lord, instead of reading the.
Yes, sir.
Chancellor, Vice-Chancellor, appointment of Vice-Chancellor, norms to be mandatorily followed, importance of post of Vice-Chancellor, relevance. State Act, if not on par with the UGC regulations held, must be amended to bring on par with the applicable UGC regulation. Until then, it is applicable UGC regulation that shall prevail. Then, my lord, furthermore, the search committee has no jurisdiction to prescribe any diluted eligibility criteria which do not strictly comply with the applicable UGC regulations. Further held, the state of Gujarat and all universities thereunder are bound by the UGC regulations. Appointment of R4 as Vice Chancellor, so and so, so and so. My lord, in the instant case, there was no nominee of the UGC, my lord, on the selection panel. So, sorry, selection committee. My lord, that was held to be illegal. This has been followed, my lord, in not less than 3 to 4 judgments of the Supreme Court subsequently.
Yes, sir.
My lord, your lordship gets it at Srijit versus Dr. Rajeshri, 2023. Then, my lord, Nagendra Singh Bandari versus.
Latest is Daru Nayak.
Otherly, it was a continuation for the second term. I think, my lord, your lordship read it. I need not repeat it.
Yes, sir.
My lord, there the Honorable Andhra Pradesh High Court has held that if the initial appointment is bad, my lord,
That is
continuation.
Daru Nayak.
Daru Naik. The continuation is bad. Then, my lord,
Now you have to tell me whether the appointment, see, in a co-warranto, the examination is limited. Examination is limited to qualification and appointment per contrary to the statute mandate of the
Please, my lord.
statute. That is all that is needed.
So-
Now, under the UGC for an appointment of Vice Chancellor, the integrity question comes into issue. That cannot be assessed in a co-warranto proceeding. Co-warranto is only 2.
my lord,
And
Then, my
ಬೇರೆ
lord,
ಏನಾದ್ರು ಇದ್ರೆ we'll consider.
that is
As far as my
7.3.
limited knowledge goes, that is.
my
that
lord,
is the two.
7.3 clearly shows that, my lord, the selection committee was not as prescribed by the UGC.
All right.
UGC regulations clearly says one nominee of the UGC and other members totally unconnected with the university.
All right.
Here there is no UGC nominee. My lord, I have produced the committee. Your lordship gets it at.
Yes, you showed me that.
My lord. ಅಲ್ಲ, selection committee, ಇವರು ಮಾಡಿದ selection committee note.
ಅದೇ ಎಲ್ಲ ಉಂಟು. Page.
My lord, 1 second. My lord, annexure H, page 85. My lord, Himamshu Rai, Director IIM Indore,
ಆಯ್ತು.
Chairman. My lord, he is the nominee of the Chancellor.
ಆಯ್ತು.
MS Shivakumar, former registrar,
You are against the last 2.
against the last 3.
Three,
Shivakumar, my lord, was the former registrar. Last two were, my lord, one of the academic council.
former registrar and former vice chancellor. Presently, what was he then?
My lord, presently he was not the registrar. My lord, the,
So, ಯಾವಾಗ್ಲೂ ಒಂದ್ಸರಿ ಅದನ್ನ ಪೋಸ್ಟ್ ನ ಟಚ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ರು ಒಂದ್ ಬರೋಂಗೇ ಇಲ್ಲ ಕಮಿಟಿಗೆ.
that is how, my lord, the Honorable Madras High Court has interpreted that. And other two, my lord, were connected with the university. One was
The
the.
other two, all right, that we'll see, we'll answer that.
Please.
Yes. ಆಮೇಲೆ.
My lord, no UGC nominee. Then, my lord,
ಹ್ಮ್.
then your lordship is not considering that, my lord, is merit in a writ of quo warranto.
ಅಟ್ಟಿಗೆ
ಅದಕ್ಕೆ ಒಂದು ಡಿಸಿಷನ್ ಬೇಕಿದ್ರೆ ಕೊಡಬಲ್ಲೆ.
ನೀವು ಕೊಡಿ, ನಾನು ನೋಡಬಲ್ಲೆ. ಎಸ್.
My lord, that is, your lordship knows, JP Kulashrestha versus somebody.
ಆಯ್ತು. ಅದೇನ್
I second class and 52%. So second class cannot be called as a distinguished academician.
ಆಯ್ತು.
Then if anything is there, my lord, they made an attempt, my lord, to trap me. My student was set in, he took me by
ಅಲ್ಲ,
car.
ಸಪರೇಟ್ ಪ್ರೊಸೀಡಿಂಗ್, ಅದಕ್ಕೂ ಕೋವಾರಂಟ್ಗೆ ಏನು ಸಂಬಂಧ?
ಅಲ್ಲ, ಅದಕ್ಕೂ ಕೋವಾರಂಟೋಗೂ ಏನು ಸಂಬಂಧ ಇಲ್ಲ.
ಹ್ಮ್.
My lord, next writ petition, my lord, that is not connected to appointment. That is something else.
ಅದೇನು ಅಗೇನ್?
ಅದು KSO ಇದು, ಕರ್ನಾಟಕ ಸ್ಟೇಟ್
ಅದು ಈಗ ನಿಮ್ಗೆ ಅದ್ ಬೇಕಾ ಇದ್ ಬೇಕಾ?
ಅಲ್ಲ, ಇದು
ಇದು ಬೇಕಲ್ವಾ?
ಹೌದು.
ಇದು ಕೇಳುವ ಫಸ್ಟ್. ಎಸ್ ಸರ್.
I am only for the university. I think the chancellor who has appointed, he has to
beneficiary or the benefactor?
speak last. Benefactor should speak first.
Yes. ಅದೇ ಜೈ ಜಯಲಲಿತಾ. 2003-7 Justice Rajendra Babu. Yes. Benefactor first and the beneficiary later. Yes.
And then root and the weed also may come here.
Yes. Nimans. Yes.
Shekhar versus
Indramma.
Indra.
Yes. So to say.
Lord,
Yes, sir.
please come to my lord, this act itself.
ಯಾವುದು?
The act, my lord.
VTU.
VTU Act.
ಅದೆಲ್ಲಿದೆ?
Certainly section 13(3).
I don't have the act, sir.
My lord, it is produced, my lord, as an annexure.
Page, sir.
Annexure C, my lord, I understand. 1 second, my lord. I'll just provide the page number. My lord, annexure E, page 30, sorry, my lord, annexure
Writ petition,
F.
ಇಲ್ಲಿದೆ. F page 35. Yes, sir.
certainly page 45. Para 13 or section 13. Subsection 3. For the purpose of subsection 2, the committee, my lord, committee is.
ಜಾಗ ಬಿಡಿ ಸರ್. ಮೈಗೆ ಜಾಗ ಬಿಡಿ ಸರ್ಗೆ.
Oh, I'm sorry. No, it's okay.
ಸಂತೋಷ್, ನೀವು ಆ ಕಡೆ ಬನ್ನಿ.
Irli, doesn't matter. Committee, my lord, shall be
Which section, sir?
section 13(3), subsection 3.
Yes, sir.
For the purpose of this subsection, my lord, that is Vice-Chancellor who shall be, for the purpose of subsection 2. Subsection 2 is, my lord, appointment of Chancellor from a council, panel of 3 persons who are outstanding in the so and so. Recommended by the committee, section 3. So the committee, my lord, shall consist of subsection 3. Member of the Academic Senate, member of the Executive Council, representative of the government, person of eminence in the field of engineering, technology, industry nominated by the Chancellor. Therefore, my lord, the Senate member and Executive Council member are connected with the university. My learned friend says that, they can't be connected. My submission is the act itself provides for it. One. Secondly, my lord.
No, he is on the UGC and not this.
Yes. Very well. Then, my lord, please look at my lord, this writ petition has been filed after 3 years. Delay and laches is another aspect. Even in
No,
Warranto.
that is first appointment. ಇದು ಅಲ್ಲ, ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗಿ 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದಾರ?
ಅಲ್ಲ,
ಇಲ್ಲ, ಮುಂಚೆ.
ಮೊದಲು ಹಾಕಿದ್ದನ್ನು ವಿಡ್ರಾ ಮಾಡಿ,
ಆಯ್ತಾಯ್ತು.
once extended, once again it was fine.
ಆಯ್ತಾಯ್ತು.
Then, my lord, we had submitted on the last judgment ಕೊಟ್ಟಿದ್ದಾರೆ Mativannan judgment, where, my lord, their lordship hold that, my lord, the state, if it does not receive any, university does not receive any aid from the UGC, my lord, UGC Act will not, my lord, apply. My lord, the State Act will apply. That, my lord, we have placed before.
So the
your lordship.
VTU Act will apply.
Houdu.
Yes.
Thirdly, more important is, please look at, my lord, the judgment of the Honorable Supreme Court itself. Annexure R4 in our objection statement. Supreme Court has, my lord, this matter came up before the Supreme Court in another companion petition. R4.
Yes, sir. Page, sir,
My lord, page 261 and 262.
261. 261.
The compilation. The compilation.
How a compilation? No? Annexure R4 to R6. Sir. ಹೌದ್ರಿ ಅದನ್ನೇ ತೋರಿಸ್ಬೇಕು. 261 ಗೆ ಬನ್ನಿ.
R4 objection.
R4. My lord, statement of objections filed by fourth respondent.
Objections of fourth.
There is no 216 at all, sir. It stops at
261.
155.
252. 252.
ಏನ್ ನಂಗೇನ್
It stops at 155.
ಎಂತದ ಮಾಡ್ತೀರಲ್ರಿ ನೀವು ಇದೇನ್ ಸ್ವಲ್ಪ ಕೊಟ್ಟಿದ್ದೀನಿ
28442.
ಏನಿದೆ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ಸಾಹೇಬ್ರ ಹತ್ರ ಬರೀ 150
ಯಾವ್ದ್ರಲ್ಲಿ ನೋಡಿ ಮೇಡಮ್. ಅವ್ರಿಗೆ ಕೊಡ್ಲಿ. ನೀವು ಐಪಾಡ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಆಗಲ್ಲ.
28442. 28442.
ಕೊಡಿ ಅದೇನು ಒಂದು ನಿಮಿಷ. ಬಿ ಶಿವರಾಜ್ da. That's the order you're saying. Yes, sir.
Please come to my lord. Petitioner filed the writ petition under Article 226
Hmm.
before the High Court for writ of warranto. They declare the appointment of respondent as Vice-Chancellor of the University
Hmm.
illegal, remove the said respondent from the office of the Vice-Chancellor, etc. Please come to the next page.
Oh, VTU then?
ಹೌದು
ಹಾ.
ಸೇಮ್ my lord, ಸೇಮ್ petition,
Same vice chancellor.
ಸೇಮ್ Vice
Same
Chancellor.
Vice Chancellor.
ಹೌದು ನೆಕ್ಸ್ಟ್ ಆಯ್ತು ನಾನು ಹೇಳ್ತೀನಿ.
ಆಯ್ತು ಡಿಸ್ಮಿಸ್ಡ್ ತಾನೆ.
Please come.
Yes, sir.
Para 3 ಬನ್ನಿ sir. It was urged. It is urged on behalf of the petitioner that a misleading government has been made before the High Court to the fact that the petitioner has suffered punishment, so and so disciplinary proceedings. Fact that the matter is that he was eventually exonerated in those enquiries. In fact, ಅವ್ರು ಏನೋ ಹೇಳಿದ್ರು. There was a committee appointed by the former judge of the High Court. My lord, he has said that there is nothing, no illegality. Anyway, may not be relevant for co-warranto.
Para 4 clinches the issue.
So far as the challenge the appointment. ಅದನ್ನೇ ಹೇಳಿದ್ದು ಅಷ್ಟೇ. Do not find any merit on the challenge. ಇಷ್ಟೇ ಇದನ್ನ ತೋರ್ಸೋದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು ಅಷ್ಟೇ. ಏನು ಹೇಳೋದಿಲ್ಲ. ಸುಮ್ಮನೆ I don't want ಅದನ್ನೇ
ಅಂತೆ.
ನಾನು ನೋಟಲ್ಲಿ ಅದನ್ನೇ ಹಾಕಿದ್ದೀನಿ ನಾನು.
ಆಯ್ಪಾಯ. Yes. Yes, sir.
ಇಷ್ಟೇ ಇನ್ನಿದಕ್ಕಿಂತ
Yes, sir.
One thing is.
Now benefactor is over.
That is the one, that is the thing.
Yes, sir.
In fact, earlier writ petition was filed, maybe by different person.
and another aspect ಒಂದೇ ಒಂದು ನಿಮಿಷ. If my my lord, if the original appointment was held to be valid, extension must can't be. That's all I would say.
All right.
I would
In
only
other
add
content,
2 sentences.
Anyway, we'll have to answer co-warranto.
Yeah, co-warranto. Whether he is doubtful integrity.
Qualification,
All those
statutory
things.
violation. ಎರಡೇ.
Statutory prescribed qualifications.
ಇದೆಯಾ
There is no
ಇಲ್ವಾ?
allegation I do not possess. They may say that I took 4 years to pass. That is not a statutory, repeaters are not entitled ante ಎಲ್ಲೂ ಬರೀರಿಲ್ಲ. In fact, one view is more number of times he has written the
More
exam,
experienced.
he will be a better engineer. ಅದಕ್ಕೆ ತೆಲುಗಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ ಪೆದ್ದ ಡಾಕ್ಟರ್ ಅಂತ ಹೇಳ್ತಾರೆ 11 ವರ್ಷ ತಗೊಂಡ್ರೆ. That is a person who passes MBBS after taking 11 years. He is a big doctor because he would have acquired so much clinical experience while in college itself. More importantly, the two judgments I would like to point out is, that is, for extension, all these will not apply. First judgment is State of West Bengal versus Anindya Sundar Das. ಅದು ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ? ಎಲ್ಲಾದ್ರೂ ಇದೆಯಾ?
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ನಾನು ಕೊಟ್ಟದ್ರಲ್ಲಿ ಇದೆ ಸರ್. ನಾನು ಆಗ ಓದಿದ್ದೆಲ್ಲ ಆ ಬಂಚಲ್ಲಿ ಇದೆ.
ಅಲ್ಲ ಇವರು ಅಧಿಷ್ಠಾನ ಅಥಾರಿಟೀಸ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ವಿ, this is ಯಾರು ಕೊಟ್ಟಿದ್ರು?
My compilation, that very same judgment, my lord, I have.
In the petitioner, in the petitioner's compilation, it is judgment 4.
Yes, sir.
61 to.
There, my lords may kindly take para 44, 51 and 52.
Sundar Das.
Anindya Sundardas, State
what-
of West
what one
Bengal
Sundar Das?
versus Anindya Sundardas.
Yes.
The chance, 44.
Yes, sir.
The chancellor has been described in section 7(1) as the head of the university. Power of appointing a VC is vested by section 8(1)(b) in the chancellor. That provision stipulates VC shall be appointed by the chancellor. Section 8(2)(b) empowers the chancellor to allow a VC to continue, notwithstanding the expiration of its term, for a period of not more than 2 years at a time in consultation with the minister. Here again, the continuation is subject to the satisfying state government and on the basis of his past academic excellence and administrative success established during the term of office in the capacity of VC. These words are in terms identical to those contained in section 8(2)(a). Section 8(5) entrusts the chancellor the power to appoint VC as a result of temporary inability to VC where a vacancy has arisen. Then kindly go to section para 51 and 52. Para 51.
Yes.
It would be appropriate to analyze whether the reappointment of the VC has to follow the same process as a fresh appointment by setting up a selection committee under section 8(1) of the Act as indicated by the chancellor. Section 8(c) stipulates the manner in which a vacancy in the office of the VC which occurs by reason of death, resignation, expiration of the term, removal or otherwise shall be filled up. The provision indicates that such vacancies shall be filled up in accordance with the provisions of subsection 1 of section 8. Section 8(6) has to be read in conjunction with 8(1) since the former expressly refers to the latter. The reference to the provisions of subsection for filling up a vacancy on expiration of the term of office will not obviously apply to a reappointment because the procedure contemplated by section 8(1)(b) of a such committee would not attach to a reappointment. On this aspect, the High Court has correctly disagreed with the petitioner before it and noted that the amended section 8(2)(a), which provides for reappointment of a VC for another term, does not require the procedure prescribed in section 8(1) has to be followed for reappointment.
What I.
Kindly see annexure A, which is the order of extension. This is under section 8(3), which Mr. Uday has already referred to 8(3). I don't want to. 8(3).
8(3) ಅಂತ ಹೇಳಿಲ್ಲ ಬಟ್
ಅದು
ಅಲ್ಲಿ
wait, act ಅದು.
Act.
ಅದು
Ah,
19(3) ಕೊಟ್ಟಿಲ್ಲ.
Kindly see this on page 25.
Mm.
Whereas Dr. Vidyashankar S was appointed Vice-Chancellor VTU Belagavi under section 13(2) of the VTU Act for a period of 3 years, by a notification GS dated from the date of assuming charge with effect from 30th September 2022, which will end on 29/9/2025.
So next 3 years is extended.
Yes. Whereas as per his request and having perused his accomplishment as the Vice Chancellor of VTU Belagavi and his ideas of further goals to be achieved merits an extension. Now therefore, I so Governor of Karnataka and Chancellor of VTU, using my discretion and in exercise of powers conferred on me by section 13(4) of the VTU Act, hereby extend the term of Dr. Vidyashankar as Vice Chancellor for another term of similar period with effect from 30th September 2025. This is the order.
So all the nuances that are necessary for the first appointment will not be there for
Will
the,
not be applicable.
for a
No,
reappointment.
For a reappointment.
ಇದೇನು renewal of permit ಅಲ್ವಲ್ಲ route.
This is not renewal of permit. Then my lords may kindly see at the page 46 of the writ petition. 45, section 13 of the VTU Act there. Section 3, subsection 3 of section 13 deals with constitution of selection committee for the first appointment. Subsection 4 governs the reappointment or extension. Subsection 4 says the term of office of the Vice Chancellor shall be 3 years, extendable by another term of similar period at the discretion of the Chancellor.
So there is no constitution of committee.
There is
or
nothing. It is pure and simple discretion of the committee. If he wants to challenge the discretion exercised by the Chancellor in favor of the fourth respondent, he himself ought to have been a candidate
No, that is, no, our co-warranto
In
ಏನ್
a
ಬೇಕಾಗಿರ್ಲಿಲ್ಲ.
certiorari, in a certiorari,
Co-warranto ಬೇಕಾಗಿರ್ಲಿಲ್ಲ ಅವಾಗ.
co-warranto ಬೇಕಾಗಿಲ್ಲ. Co-warranto ನಲ್ಲಿ scope is limited.
Yes.
Limited scope, kindly see the proviso below subsection 4.
Proviso to
Provided
what?
that,
Hmm.
that is about the resignation.
Yes.
Therefore, this appointment is admittedly traceable to subsection 4 of section 13 of the VTU Act. It does not speak of. Then I pointed out earlier that apart, there is another judgment of the Supreme Court, that is Dr. Premachandran Kilot versus Chancellor, Kannur University. Year 2024. I think on behalf of the university, it was given, my lord, sir. What do you want? Copy. ಅದು ಇದ್ದಂಗಿಲ್ಲ ಬಟ್ ಅವ್ರು ಕೊಟ್ಟಿರೋದು ಇದ್ರೆ ನೋಡಿ, ಅವ್ರು ಕೊಟ್ಟಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ಸ್.
ಇದು ನಿಮ್ದ ನಾರಾಯಣ್ ಭಟ್ ಸರ್.
I am also relying on the same judgment.
ರಾಮಚಂದ್ರನ್.
Kilu versus Kannur University.
ಇದು yes.
Premachandran
Yes, yes.
Kilot.
I got it.
Paragraphs 58, 59, 60. Paragraph 58.
Ah.
At the bottom of the left-hand column of page 161.
Yes.
Reappointment of Vice Chancellor has been provided under subsection 10 of section 10 of the Act 1996.
Hmm.
The proviso to subsection 10 of the Act now further makes the intention of the legislature to provide for reappointment more clear. The legislature has not thought fit to prescribe any particular procedure or any particular mode or manner of reappointment. The UGC regulations are also silent as regards the reappointment of Vice Chancellor. The language of subsection 10 of section 10 of the Act 1996 is plain and simple. The provision does not confer right to seek reappointment. There is only one way of reading the provision, which is that a Vice Chancellor once appointed, subject to the provision of subsection 10 of section 10, is eligible to be considered for reappointment. What this implies is that an incumbent Vice Chancellor may not have to reapply along with other candidates and compete for the same position once again. Reappointment essentially means the incumbent Vice Chancellor would receive another term of 4 years if the Chancellor deems fit, without reopening the position for new applications or without constituting a selected committee. Re means again and is freely used as a prefix. It gives color of again to the verb with which it is placed. Reappointment as an act of process of being appointed again is act or process where the appointment is to be made for the first time or where the same person is being reported second time, but not in continuation of the term. The procedure prescribed under section 10 must be gone through. Here, my term was expiring on 30th of September. The extension has been granted on 3rd September. It is pure and simple, traceable to subsection 4 of section 10. There cannot be any. Then, of course, several things I said, all those things we have placed on record with the objection statement of 4, that suspension. Ultimately, the disciplinary proceedings concluded by an order passed by the management of the Vakkaligar Sangha, where they said
And one
the
more.
proceedings are dropped.
Then Senior Counsel Udayala sir said that the judgment, you don't receive any grants, then UGC is not applicable.
Yes.
Which is that? Judgment.
That is-
Mathivannan's and two other.
Manivannan, all right, yes.
Then another thing they said, my name was included in the FIR.
Hmm.
Charge sheet has been filed where I have been dropped.
Huh.
My name is given up. This is my lord, sir, just.
It was the part of the
ಅಲ್ಲಿ
PIL.
KSOU.
Huh?
PIL ಹಾಕಿದ್ರಾ?
PIL ಬೇರೆಯವರು ಹಾಕಿದ್ರು. ಅದರಲ್ಲಿ that was the charge. Against the petitioner, there was an injunction not to reveal that. On that ground, my lord, that PIL was dismissed, not on merits.
All right, yes.
Not on that, not
My
on
lord, may I
merits.
just, by way of
Lords,
reply?
I beg to appear for the Vice Chancellor. May I make a submission?
Sir appear ಆಗಿದ್ದಾರೆ
I
ಈಗ.
appear for the university.
University. Is appearing. Yes, sir.
Lordships. My lords, before I go into the merits,
For
I would like-
1 minute, sir.
For the-
Sondi sir, 1 ನಿಮಿಷ.
please, my lords, I'll wait.
Judgment the lordships wanted, Mativannan and Uttarakhand. Nodi.
ಓಯ್ ಕಲ್ಯಾಣಿ ಮದಿವನ.
ಹಾ.
Yes.
ಅದು
By the way,
ಆಮೇಲೆ
that's all.
ಇನ್ನೊಂದು
Yes.
four is, my lord, that state of Uttarakhand versus Sudhir Budakot.
No problem. ಕಲ್ಯಾಣಿ ಮದಿವನ.
With this, my lord, sir, about the conduct of the petitioner who questions even under co-warrant. That is Srinivasa Reddy is relevant, my lord.
ಶ್ರೀನಿವಾಸ್
That's
ರೆಡ್ಡಿ.
84 to 87
Yes.
about the conduct. Para 51 to 54 is the limits of
Co-warrant.
co-warrant.
ಲಕ್ಷ್ಮಣನ್.
Yes, my lord.
Yes, sir.
Not single, division bench.
ಅಲ್ಲ ಜಸ್ಟಿಸ್ ಎ ಆರ್ ಲಕ್ಷ್ಮಣನ್.
DMP ಇಲ್ಲಾದ್ರೆ ಒಬ್ಬರೇ ಕೂತ್ಕೊಂಡು ಬರೀತಾರೆ.
ಅಲ್ಲ ಜೊತೆಗೆ ಆತರ ಅವರೇ ಅಲ್ವಾ?
ಹೌದು.
Author is,
Author is
ಆತರ
Dr. Lakshmanan.
ಡಾಕ್ಟರ್ ಲಕ್ಷ್ಮಣ್, ಎ ಆರ್ ಲಕ್ಷ್ಮಣ್. ಜಸ್ಟಿಸ್ ಡಾಕ್ಟರ್ ಎ ಆರ್ ಲಕ್ಷ್ಮಣ್.
yes, sir.
Yes, sir. Anything in re?
Yes, my lord.
Because this is reappointment.
Please.
Lords, may I in the meanwhile make my?
Oh, yes, sir. Let's only sir finish. Yes, sir.
Lordships forgot about me.
No, sorry, sir.
I realize
that-
I'm on VC.
No, that is beyond possibility.
I'm so grateful.
Yes, sir.
Lords, before I make a couple of submissions on merits, there is one submission on the conduct of the petitioner that I want to highlight. There is an IA for dismissal that we have filed.
Hmm.
Basis a development that took place while the matter was seized off.
ಜಾಗ ಇಲ್ಲ sir. Yes. ಅಭಿಷೇಕ್.
On 3/2/2026, when the matter, my lords, had been heard before an earlier bench,
Yes, sir.
a demand was made, my lords, on this respondent by the petitioner for payment of 1 crore to withdraw the case. And this is, yes, and this is not a bald or irresponsible statement I'm making. I promptly registered an FIR and there is a charge sheet for extortion now laid against this
My lord,
gentleman.
I have also registered a.
All right.
Sir,
You
one
will
minute,
reply.
you'll have to
Wait.
wait.
Yes,
I know
yes.
my friend would like to say something. Their
Yes,
FIR, a B report is filed. It's a counter blast. On my FIR, there is a charge sheet filed and I have placed that before your lordships, along with my IA, my lords, for dismissal of the petition and with a copy of my complaint and the charge sheet.
It's
So,
on
my lord,
record.
It's on your lordship's record.
Yes.
And I'm requesting my colleague to just point out the page number. The IA for dismissal is there, my lord. The charge sheet came a little later. Charge sheet was filed a little later. That was also placed before your lordships with a memo. Now, my lords, in a quo warranto, even more than an ordinary writ petition, the conduct of a petitioner, my lords, has to be absolutely clean. Because your lordships are aware, quo warranto is the one writ where locus is ordinarily relaxed. But it is relaxed with a corresponding duty on the part of the petitioner to have absolutely clean hands. And this fact, my lords, in my very respectful submission, is sufficient to reject the petition, my lords, on conduct and equity. And there is a related conduct development, which is that earlier your lordships are aware a PIL was filed. That PIL came to be dismissed, my lords, with strictures on the petitioners therein. Here, the writ is filed by way of a private writ petition, not as a PIL. Possibly because the disclosure requirements, my lords, under the PIL rules may be higher. I do not know what considerations weighed with the petitioner.
That's why co-warranto. Yes.
Even there, my lords, the challenge was to my
No,
appointment.
that is read with co-warranto. It's pure
The
co-warranto. Yes.
Sum and substance, my lords, co-warranto, whether a PIL or not, the locus requirement is generally
No,
relaxed.
correct. Yes.
So, but my lords, in that PIL, when the petition was dismissed, the petitioner therein, represented by my learned friend there also, though a different party, took the matter to the Supreme Court. And there, my lords, I do not know if the order of the Supreme Court has been brought
That
to your
is
lord.
Shivraj.
That's right.
Yes.
Lords, your lordships have perhaps seen para 3 and 4.
4. Para 4 is enough. Yes.
Yes, my lords. Challenge to the appointment of R3 as Vice-Chancellor is concerned, we do not find any merit in the challenge. So, arguments were made on merits on these very grounds, and arguments were made, my lords, also to entertain the PIL, saying that his conduct was all right. The SLP was dismissed with liberty to file a review. I'm instructed no review has been filed. But be that as it may, on the merits, my lords, that order closes the issue. Lordships have also seen, my lords, section 13, which my esteemed friend Mr. Rajgopal had pointed out, that the extension under 13.4 is very different from the in limine appointment. Virus of 13 or 13.4 is not in question. Much water has flowed. I have already completed one term as the Vice-Chancellor. No challenge was brought except at the fag end, my lords, in the PIL. And one of the observations in the PIL was laches. Now here there is no challenge, my lords, to the virus of 13.4. Under 13.4, my lords, the extension is at the discretion of the Chancellor. It's a very different consideration. It's not even a reappointment in that sense, my lords. It is an extension. And therefore, to link it to the original appointment, my lords, would be reading the UGC regulations in a completely misconceived light, as the petitioners have sought to do. And the extension, my lords, is granted by the Vice-Chancellor. The order granting extension is in your lordship's file. After considering, my lords, the report from the government, the credentials of the petitioner, and various other factors, a speaking order is passed, my lords, by the Chancellor in exercise of this statutory power. And certainly, my lords, as far as 13.4 is concerned, UGC regulations have absolutely no overlap. On the larger question, my lords, of the applicability of the UGC regulations, my lords, learned senior Mr. Holla has referred to two orders. There is also the judgment in Loknath of a division bench of this honorable court that when it comes to institutions that are not funded, then the UGC applicability itself is doubted. And my lords, in fact, I think your lordships have already seen the other orders also. I don't want to repeat the orders, my lords, in Kalyani and others. So there is the larger question, my lords, of applicability of the Act itself. And one other aspect is, my lords, keeping aside all other questions, is that, my lords, under section 19 of the Act, the authorities of the university, a nominee of the UGC is ex officio a member of the Executive Council. So any which way, this submission that UGC's blessings have not been obtained, my lords, for the appointment of the Vice-Chancellor really is a nominal or a notional submission, because the UGC is in the know of what has happened. The situation under the VTU Act is very different from the other statutes that have been interpreted, my lords, by the Kerala High Court and other courts. Here, UGC is represented ex officio in the Executive Council. I believe your lordships have seen that, my lords. Yes. And on that extension, since I made a reference to it, page 25, my lords, is the order of extension granted by the Chancellor in force since 3/9/2025, basis the report, my lords, placed by the state. So those are my submissions, my lords, on merits, but I would very respectfully request your lordships to consider, my lords, the conduct of the petitioner. It's not a bald allegation. There is a charge sheet laid against them, basis the direct allegation of trying to influence, my lords, not only this is not about the parties, my lords, this is about the purity of the process of the court. And that is today the subject matter of the charge sheet, and also, my lords, the background of the PIL that was filed leading up to this petition. I'm grateful.
Yes, sir. But sir,
My lord, first submission, my lord, by senior counsel Mr. Uday Holla is that, my lord, if no aid, Mathivarnan, and not applicable. My lord, the statute clearly says, your lords may kindly turn to Annexure E.
statute is UGC or?
UGC. It clearly states that, my lord, these regulations may be called as university grants, minimum so and so regulations, appointment of teachers and other academic staffs in universities, colleges, and other measures for maintenance of standards in higher education regulations. These shall apply to every university established or incorporated by or under the Central Act, Provincial Act, or a State Act, every institution, including a constituency or affiliated college recognized by the commission in consultation with the university concerned, so and so, section 2 of the Universities Grants Commission Act, and every institution deemed to be a university under section 3 of the said act. There is no reference to aid. Added to that, my lord, I have filed an affidavit. My lord, if your lordship finds it difficult to trace it, I'll provide it.
Find it difficult to
Trace it.
trace it. Ah, good.
Fine. My lord, Annexure L6, page 5. My lord, it is a notification of 1999. My lord, this university was established somewhere in 98 or 99. A new university, namely Visvesvaraya Technological University, Belgaum, has been established by an act so and so of Karnataka State Legislature and notified by state government notification so and so. The said university is included in the list of universities maintained under section 2F of the UGC Act. The above university has, however, not been declared fit to receive central assistance in terms of the rules under section 12B. Then, my lord, this university made an application, Annexure L7, page 6. Proposal for inclusion of the list of universities under section 12B of the UGC Act. This is addressed to the VTU in the year 2018.
Yes.
This is in reference to so and so. The committee considered the report of the UGC inspection committee along with the complaints submitted by the university. Committee decided to recommend approval of 12B status to the university so and so, Belagavi. The university is advised to get NAC accreditation at the earliest. The recommendation of the committee along with the report of the UGC inspection committee were placed before the commission on 5/27, so and so, so and so. The commission considered and approved the recommendation of the committee, and the university is included in the list under section 12B. 12B, my lord, if your lordship sees, it is pertaining to grant of aid. Your lordship may kindly see next document, Annexure L8. My lord, the relevant portion, my lord, is at page 11. Serial number 104. Visvesvaraya Technological University, Jnana Sangama, Belagavi, page 11, top ali. ಅದು ಶೇಡ್ ಮಾಡಿದ್ರಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ಪರವಾಗಿಲ್ಲ.
My lord, this is a university, my lord, registered for grant of aid. My lord, how much aid is received, my lord, from the UGC? How much aid is granted by the central government? My lord, the custodian of the record is the university. I do not have any access. So it is incorrect to state that this university is not receiving aid. It is not a factually correct statement. You make an application that I want aid. My lord, that is taken after inspection, my lord, the UGC allows that. You are registered under 12B to receive aid. You cannot say that I am not at all receiving. Maybe when it was established, it was not receiving. From 12,018 onwards, my lord, it is registered for aid.
12,018?
2018 ನಂತರ ಅಲ್ಲಿಯವರೆಗೆ aid ಇರಲಿಲ್ಲ. My lord, then my lord, another submission was that state act ಪ್ರಕಾರ ಮಾಡಿದ್ದೀವಿ ಅಂತ. My lord, there are two Supreme Court judgment. One is Gamardhan Gadil. My lord, even if it is a regulation framed under the UGC, my lord, it becomes a part of the act and it will prevail over the state act. States have been advised, my lord, amend their regulations. If they don't amend their act, my lord, the Honorable Apex Court has observed that it shall be the UGC regulation alone which will govern the field. If that is the position in law, my lord, without inclusion of the UGC nominee and including two members, my lord, who are the sitting members of the EC and academic council, my lord, the selection is bad. In a writ of quo warranto, there is no delay and latches.
Don't worry about that. Don't labor on that at all. Yes.
Then
As long as he is holding the post, there is a ground. Yes.
Then my lord,
ಕೋವಾರಂಟೋಗೆ ನೀವು ಲಾಸ್ಟ್ ಡೇನೂ ಹಾಕ್ಬೋದು.
then my lord,
ಡಿವಿಷನ್ ಬೆಂಚ್ ಒಂದು ಲಾಸ್ಟ್ ಡೇ ಕೋವಾರಂಟೋ ಕೊಟ್ಟಿದ್ದಾರೆ. Yes.
my lord, then one more submission is that, my lord,
Delay.
Huh?
Supreme Court ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, delays of no consequence.
ಅಲ್ಲ, in this court, next day he was to retire, previous day it was pronounced ಕೋವಾರಂಟ್. Yes.
then my lord, the next submission is that, my lord,
Mm.
the extension is required to be done, my lord, on his own by the appointing authority, the chancellor. It is not, my lord, on a request made by the sitting vice chancellor or on a recommendation made by the government of Karnataka. That, my lord, your lordship gets that clear.
Will that vitiate the reappointment?
It will vitiate the reappointment. That is, my lord, what has been observed in that Kannur University, which your lordship referred, my lord, in the,
All right, yes.
my lord, I just read it,
Oh,
my lord,
what
for
you-
my satisfaction.
I know, sir, even my satisfaction also reads.
My lord, point number, 4 points were framed, my lord, by the Honorable Apex Court.
Yes.
Your lordship gets those 4 points, my lord, in. My lord, page 83 of that today just given bench, my
Yes,
lord.
yes, sir. Page 83.
Page 83 ಅಲ್ಲಿ ಇದೆ.
Yes, sir. ಇವಾಗ ನೀವು ಕೊಟ್ಟದ್ದಲ್ಲ?
ಈಗ ನಾನು ಕೊಟ್ಟದ್ದು.
ಹಾ.
My lord, senior counsel Mr. Rajgopal read that.
ಹೌದು ಗೊತ್ತು, ಇಲ್ಲೇ ಉಂಟು, ಹೇಳಿ.
Page 83 ಅಲ್ಲಿ 4 points are framed on the left hand side, your lordship gets it.
ಹಾ,
Having para 40.
ಹಾ,
Having heard the learned counsel appearing for the parties and having gone through the material on record, the following questions of law fall for our consideration. Whether the reappointment permissible in respect of tenure post, whether the outer age limit so and so, whether the reappointment of the vice chancellor has to follow the same procedure. Fourth, my lord, all the 3 are held against the petitioners, writ petitioners. Fourth, did the chancellor abdicate or surrender his statutory power of reappointment of the vice chancellor? My lord, this finding on this is, your lordship gets it at para 81.
ಹ್ಮ್.
My lord, para 80,
Page 93.
page 93.
ಹ್ಮ್.
It appears from the press release issued by the Kerala Raj Bhavan dated so and so that the opinion of the Advocate General also sought for in connection with the reappointment of the respondent number 4 as Vice Chancellor. The very first part of the press release states that Kerala Raj Bhavan strongly refutes the claim in some news reports that it was on the direction of the Honorable Governor that the name of Dr. Gopinath Ravindran was suggested for reappointment as Vice Chancellor Kannur
On
University.
this point, it is held vitiated.
It is held vitiated. Here,
At-
my lord,
at
recommendation of the
para-
government,
Para 86.
para 86.
Hmm.
So, my lord, your lordship may see the records. My lord, according to their submissions, they took the report of the government of Karnataka and the representation of the sitting vice chancellor. My lord, if that is so, this para 4 applies. My lord, finding on para 4 applies and this is vitiated. Next submission is, my lord, special leave petition dismissed. My lord, friends did not read the entire order of the special leave petition. My lord,
ಅದೇ ಶಿವರಾಜ್ದು.
Shivraj, this honorable, my lord, I appeared for Shivraj. My lord, there was an injunction against one of the petitioners, not against Shivraj,
ಹ್ಮ್.
not to make a statement on his sex scandals.
Eh?
My lord, there was a criminal case
ಹ್ಮ್.
for harassment of a woman in workplace in KSOU.
ಯಾರಿಗೆ
Fourth
ಶಿವರಾಜ್?
respondent,
ಶಿವರಾಜ್.
Shivraj ಅಲ್ಲ, fourth respondent.
ಓ, ಆಯ್ತು. ಹ್ಮ್.
My lord, that the another petitioner, my lord,
ಅಲ್ಲ, ಅದರ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಯಾಕೆ ಈಗ?
otherly, that was dismissed on that ground.
Oh.
There was an injunction operating against one of the petitioners not to divulge, and this fact was divulged, my lord, in the PIL.
Hmm.
When there was an injunction, he should not have divulged. So his on his conduct, my lord, it was dismissed.
Hmm.
In the writ petition order, my lord, this honorable court has observed that we are not touching the merits of the case, and we are only dismissing on this ground. Is the observation. This honorable court did not touch the merits. My lord, if your lordship,
That was taken to the Supreme Court.
that was taken to the Supreme Court. May I just pass on that judgment, my lord?
Hmm.
My lord, may I just pass on that judgment, my lord? I have only one copy.
Hmm.
My lord, I'll just read one sentence and pass it on, my lord.
Hmm.
However, in our considered opinion, petitioners rights and petitions have not approached the court with clean hands, clean heart and clean objective. This apart, there is a short unexplained delay on the part of the petitioner calling in question. So and so, so and so. Then It has been settled position in the domain so and so, my lord, they observe. In the above circumstances, these petitions are dismissed with cause having been made reluctantly easy. We make it clear that we have not expressed any opinion as to the regularity or otherwise of the entire proceedings that culminated in the appointment of the third respondent in this petition as Vice Chancellor of the fifth respondent university. It is also made clear that the observation here in above made being confined to the disposal of these cases. Then, my lord, the matter went to the Supreme Court. Here nothing is decided on merits.
Supreme Court, nothing is decided on merit.
My lord,
But paragraph 4 only, it is said.
my lord,
we
it
do
is
not-
true.
uh,
My lord, no notice is issued. My lord, on that,
No, notice is
no
not.
notice is issued. It was a dismissal in limine. If such an observation is,
ಲಿಮಿನಿಗೆ ಇಷ್ಟೊಂದು ಬರದ್ರ
ಹೌದು.
ಅಂದ್ರೆ ಲಿಮಿನಿ ಹೋಯ್ತದು.
ಅಲ್ಲ, ಲಿಮಿನಿ ಹೋಗಲ್ಲ. If SLP is dismissed, my lord, I may be permitted to.
It's no ground dismissed, ಅದು ಲಿಮಿನಿ.
ಅದಾದ್ರೂ ಹೀಗಿದ್ದ ಅಬ್ಸರ್ವೇಷನ್ ಇದ್ರು ಬರಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆ.
ನೋಟಿಸ್ ಕೊಡದೆ ಮಾಡಿದ್ರೆ ಲಿಮಿನಿ ಅಂತ.
ನೋಟಿಸ್ ಕೊಡದೆ ಮಾಡಿದ್ರೆ ಲಿಮಿನಿ ಅಂತ ಇದೆ. Your lordship may kindly take, my lord, the bunch which I have provided.
I am in that bunch only, sir. Yes.
My lord, first is first judgment. My lord, para 7. My lord, it is at page, my lord, para 7 ಬಂದ್ಬಿಟ್ಟು page 13 ರಲ್ಲಿ ಇದೆ.
Para 17, sir.
ಅಲ್ಲ, para 13.
13.
ಅಲ್ಲ, page 13, para 7.
ಹಾ.
So far as the first question is concerned, Article 141 of the Constitution unequivocally indicates that the law declared by the Supreme Court shall be binding on all courts within the territory of India. The aforesaid article empowers the Supreme Court to declare the law. It is therefore an essential function of the court to interpret legislation. The statements of the court on matters other than law, like facts, may have no binding force, as facts of two cases may not be similar. But what is binding is the ratio of the decision and not any findings of fact. This, my lord, your lordship may kindly see. SLP dismissed in limine, SLP dismissed with some observation, one sentence observation, not touching the merits. SLP dismissed after grant of leave, my lord, civil appeal is registered and one sentence order is passed. Then, my lord, a detailed order in civil appeal. In the two former cases where SLP is dismissed by one sentence or one paragraph order, my lord, the Honorable Apex Court has held that it is not a binding precedent and it is not a finding on merits. My lord, the second judgment on that is, my lord, 2019 6ACC, page 270, para 9.2. My lord, your lordship gets it at page 24. My lord, the relevant portion is 9.26 and para 9.27.
ನನ್ ಬಾಟಲ್ ಬೇಕು. ಫ್ರೆಶ್ ಬಾಟಲ್ ಅವರು ನನಗಲ್ಲ. ನಾನೇನ್ ಮಾಡ್ಬೇಕು? ಎಲ್ಲಿ ಫ್ರೆಶ್ ಒಂದು ಬಾಟಲ್ ಕೊಡು.
My lord, finally, the High Court had relied upon the decision of Muktiranjan Acharya versus so and so to hold that the promotions could be given under so and so, so and so, so and so. The counsel for the contesting respondents prayed for dismissal of the present civil appeals by submitting that the said decisions had not been affirmed by this court wide order dated so and so. It is well settled principle of law emerging from catena of decisions that, including Supreme Court Employees Association, that dismissal of an SLP in limine simply implies that the case before this court was not considered worthy of examination of reasons which may be other than the merits of the case. Such in limine dismissal of the threshold without giving any detailed reasons does not constitute any declaration of law or a binding precedent under 141. My lord, there is one more decision, my lord, 2000, volume 6 ACC 3459.
Sir, that is rudimentary. ಏನ್ ಬೇಡ. That is too rudimentary.
ಆಯ್ತು, ತಾವು ಬೇಡ ಅಂತ ಹೇಳಿದ್ರೆ ಮತ್ತೆ ನಾನು
ಅಲ್ಲ, ನೀವು ಓದ್ಬೇಕಂದ್ರೆ ಓದಿತ್ತು.
ಅಲ್ಲ, ಓದಲ್ಲ. ಅದರಲ್ಲಿ ಹೇಳಿದೆ ಅಂದ್ರೆ ಹೀಗೆ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ SLP ವಿದೌಟ್ ನೋಟಿಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಅದು ರೆಸ್ಯುಡಿಕೇಟ್ ಅಥವಾ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಫೈಂಡಿಂಗ್ ಅಂತ ಬೈಂಡಿಂಗ್ ಅಂತ ಇದೆ. ನಾನು ತಮಗೆ ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ದಿನನಿತ್ಯ ತುಂಬಾ ಜನರಿಂದ ಇದನ್ನು ಕೇಳಿಸ್ಕೊಂಡು ತಾವು ಬೇಜಾರಾಗಿರ್ತೀರಿ.
ಇಲ್ಲ, ಆತರ ಏನಿಲ್ಲ. ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನು ಬರೀಲಿಲ್ಲ ಅಂದ್ರೆ, ರೇಷಿಯೋ ಇಲ್ಲ ಅಂದ್ರೆ ದಟ್ ಫೈಂಡಿಂಗ್ ಇಸ್ ನಾಟ್ ಬೈಂಡಿಂಗ್.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದಾರೆ even otherwise we do not find merits in the contentions ಅಂತ. ಮೆರಿಟ್ಸ್ ಏನು ಹೈಕೋರ್ಟ್ ಏನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದೆ ಅದರಲ್ಲಿ ಮೆರಿಟ್ ಇಲ್ಲ ಅಂತ. ಹೈಕೋರ್ಟ್ ಮೆರಿಟ್ ನಲ್ಲಿ ಏನು ಹೋಗೇ ಇಲ್ಲ.
ಅಲ್ಲ ಅದಲ್ಲ, 4ನೇ ಪ್ಯಾರಲ್ ಇರುವುದು
ನಾಲ್ಕನೇ
ಹೈಕೋರ್ಟ್ ಮೆರಿಟ್ ಅಲ್ಲ, ಕ್ಯಾಂಡಿಡೇಟ್ ಚಾಲೆಂಜ್ ಮೆರಿಟ್ ಇಲ್ಲ ಅಂತ.
ಸ್ವಾಮಿ ನಾನು ಓದಿ ಬಿಡ್ತೇನೆ ಅದನ್ನು.
ಅಲ್ಲ ಇರ್ಲಿ ಬಿಡಿ,
ಅಲ್ಲ ಓದಿ
ಓದ್ಬಿಡು.
My lord, para 3, my lord. It is urged on behalf of the petitioner that misleading governments had.
ಅದು ತಗೊಳ್ಳಿ.
Thank you, my lord.
Some more energy.
I am grateful to your lordship.
Yes, sir. Water.
More energy is required, my lord, to off.
That is why I gave it to him.
ಅಲ್ಲ ನಮಗ್ ನೀರ್ ಕೊಡ್ಸಕ್ ಬಂದು ಅವರೇ ಕುಡಿತಾ ಇದ್ರು.
ಓ,
ನಾವು
ಈಗ ಅವ್ರು ಕುಡಿದ ಮೇಲೆ ನಿಮಗೆ ಕೊಡಿಸ್ತಾರೆ ಇರಿ. ಬಂತ.
It is urged on behalf of the petitioner that the misleading government was made before the High Court to the fact that the petitioner had suffered punishment pursuant to disciplinary proceedings. The fact of the matter is that he was eventually exonerated in those inquiries. However, petitioner did not get any opportunity to bring the such material on record before the High Court. It is also contended that the other circumstances, eitherly punishment to petitioner, my lord, to impeach the integrity of the petitioner, they produced some show cause notice issued by the government. Ultimately, my lord, it ended in his exoneration.
That is Shivaraj.
So far as the challenge to the appointment of the respondent number 3 as Vice-Chancellor of the university is concerned, we do not find any merit in such a challenge. The view taken by the division bench of the High Court does not warrant any interference. As regards to the adverse comments made by the High Court so and so, eitherly merit na mele agli, UGC regulation ಬಗ್ಗೆ agli, this honorable court also did not debate, nor, my lord, there is any observation on the appointment or following the UGC regulation or any such thing. In that view of the matter, my lord, my respectful submission is this cannot be treated as a precedent, and the Honorable Supreme Court itself, my lord, in Kunyamat case has observed these 4 categories. SLP one line dismissal, without notice SLP dismissal with some observations. Kunyamat, my lord.
2008 ICC, yes. Yes, is Thomas ಅವ್ರದ್ದು, yes. ಆಮೇಲೆ
then, my lord, my
that's followed in Kodes, sir, in 2018, 3 judges. Yes.
Ade Kode distillery
Ade, Kode
Madheshwara sugar.
Yes, sir.
Then, my lord, my learned friend Mr. Sodhi, my lord, was on B report and registration of charge sheet.
Sodhi sir, why you went away?
My lord,
I'm here.
So visibility had gone.
My lord, I have filed a detailed affidavit, my lord, what transpired and how all these things have happened.